Good afternoon and welcome to the Appellate Division First Department. Most of you know the drill. Please ask the time you need, not the time that you want, understanding that the court is familiar with the record, the briefs, and the clock is for you, not for us. So if we have more questions, we will go beyond the time, okay? All right. Sons versus Department of Education. Okay, off to a good start, submitted. H children, submitted. 75 commercial versus on. Okay, do you wish to submit or do you want to argue? Thank you. Please have a seat until the end of the calendar. Arena Investors versus D'Angelo. Okay, and how much would you like? You didn't hear my speech, apparently. You're going to be. And how much time do you want? Okay, how about 7 and 2 and 7? As I said, if we have more questions, we will continue. All right. People versus Betances. Oh, there's another. I'm sorry. And you are for whom? Okay. So, all right. And how much time do you want? 10 minutes. No. Try again. Try again. All right. You're going to get 5 minutes because already one of the appellants has 7. Okay? All right. People versus Betances, submitted. Mezinev versus Tasha Bekova was heard earlier. Gun Hill Liquor versus New York State Liquor Authority. Appellate, do you wish to submit? Sure. Thank you. Smith versus Shea. Okay, respondent? No respondent. Thank you so much. People versus Hermes Gonzalez. Submitted. 500 8th Avenue versus Resource Training. Thank you so much. Submitted. Jeremias versus Lincoln Life and Annuity. Okay. 6 and 2 and 4. Reynolds versus New York City Fire. Okay. 5, 2, and 5. Thank you. Morrison versus NYCHA. 5 and 2 and 4. Jones versus Grooms is submitted. Alvarez versus Charles Street Owners is submitted. First case on the calendar, Arena Investors versus D'Angelo. Me too. All right. You may proceed, sir.
Good afternoon. May it please the court. My name is Timothy Pastor with the law firm Montgomery, McCracken, Walker, and Rhodes, and it's my pleasure to introduce John J. Richardson of the Bernstein Berkeley firm, who has been duly admitted pro hoc vice to argue on behalf of the appellant.
That application is granted. Counsel, you may proceed.
Good afternoon, members of the panel, and thank you, Attorney Pastor, for sponsoring my admission today. My name is John Richardson. I represent the appellant in this matter, Stephen D'Angelo. The question before the trial court was straightforward. Under CPLR 3213 and New York law, does an individual member of a collective lending syndicate have the independent right to enforce a personal guarantee and obtain summary judgment in lieu of a complaint, where the guarantee itself is held by the collective, not by the individual lender, and where the guarantee, inside the four corners of the guarantee, there is no grant of individual enforcement rights in favor of any individual lender? The answer to that question under New York law and the record before the trial court was no. And with all due respect to the trial court, it committed reversible error when it held otherwise. The Supreme Court of New York, in a case called Credit Français International, which we discussed.
Well, wait a minute. Are you saying no as a matter of law, or are you saying no, you couldn't get summary judgment on that ground? Those are two different things.
I'm saying the latter. On the record that was before this court and within the constraints of 3213, where the court was confined to reviewing just the four corners of the operative money instrument, which in Mr. D'Angelo's case was the guarantee, not the underlying finance agreement.
Yes. Are you saying it is a question of fact, or as a matter of law, that document doesn't permit one party?
Our position is that under Beale, the Court of Appeals case.
I just want to know, what are you arguing? Are you arguing as a matter of law that you can't, that the one of the two couldn't sue, or as as a matter of law, you can't tell from that document?
Both. I'm saying as a matter of law, the individual lender was not permitted to bring this enforcement action absent any specific language in that guarantee permitting.
So no case says there is a requirement for specific language, correct? You look at the document, see what it says, correct?
Correct.
So in this document, it doesn't say that only the collective or even a majority or some of the other language that would normally be used to indicate a collective requirement is not in this document. On the other hand, there's nothing in this document either way, correct?
Exactly. The document
I don't know how you could say that as a matter of law, it would go one way or another. That's what I'm...
We're saying as a matter of law, the trial court could not decide under 3213 on the record that was before it what the intent of the parties was. Because under Beale, the lead case we've cited, you default to the intent of the parties when the document is silent. And we're saying that's where the first misstep the court made was, if the court decided that from the face of the guarantee in the four corners, it could not determine the intent, once it went beyond those four corners, it was outside of 3213.
So you're not denying the default, and you're not denying the amount due. You're only denying that this party has the right to individually sue under the...
We're not denying that the primary borrowers defaulted, and we're not denying that Mr. D'Angelo has not made any payments under the guarantee. We do argue in our papers that Mr. D'Angelo is unable to determine the accuracy of the amount.
No, that's not enough. Do you put in anything to raise an issue of fact with respect to the documents that the move-in put in as to how much money is owed? If all he's saying is, I don't know that it's true, I have not yet once found a case that said that that's sufficient. So my question is, did you put in any documents that would require a hearing on the amount due?
Mr. D'Angelo did not at the 3213 stage, no, Your Honor.
Well, that's the summary judgment stage, right? Didn't put in anything in opposition.
It was summary judgment in lieu of a complaint, but yes.
I know what yes, absolutely.
Yes.
Okay. So really the only issue here is whether the move-in can sue individually or is required to sue together with Capstone, correct?
That coupled with whether this trial court could make that determination under the 3213 rubric. That's correct.
Is there anything else you wanted to?
Since I'm running short of time, I'll just point out.
You still have 2 minutes.
The court did look beyond the guarantee and seemed to have focused on the underlying finance agreement. Mr. D'Angelo was not a party to that finance agreement. He had nothing to do with, he did not negotiate that as to himself. That agreement does include joint and several enforcement language. And what that is indicative to, and we would have thought would have been indicative to the trial court, was these are sophisticated commercial parties. They had sophisticated lawyers. If they had intended for a right of individual enforcement to be present in the guarantee, they demonstrated the wherewithal to negotiate and include that in the guarantee. The fact that it is absent is indicative of an intent that there was no agreement that an individual lender could go off on its own and enforce the guarantee. As to Mr. D'Angelo personally, the primary borrowers aren't here on appeal because they're under a different agreement, and there was unilateral enforcement rights in those finance agreements. I think I can rest with that.
Thank you.
Thank you.
Counsel?
Good afternoon.
Good afternoon.
Dorian Pancherson on behalf of the respondents, Arena Investors and Arena Limited SPV. My esteemed colleague, Mr. Richardson, rightly acknowledged there's a few facts here, as the court is well aware, not in dispute. No dispute that Mr. D'Angelo borrowed millions of dollars from my client. No dispute that there's a set of loan documents memorializing that transaction, and certainly no dispute that the borrowers were in default, and Mr. D'Angelo himself has not made good on his obligations under these personal guarantees. As the court rightly noted a moment ago, within the four corners of this agreement, there is nothing that says an individual lender is barred from pursuing their own remedies as they would otherwise be entitled to do. Now, what Mr. D'Angelo wants us to believe is that there is a fiction somehow emanating from these agreements that says, notwithstanding the lack of that language,
Is there any language in the agreement that says individually or jointly and severally, which you would normally see in the situation where one or the other? I mean, you're the minority buyer, lender, correct? You're not.
We are
not
not
the majority lender.
We are the majority.
I thought
you're not.
Capstone said it was the majority lender.
You can't add. No. The record is very clear that Capstone is the majority lender, and for you to even attempt to say otherwise is disingenuous at best.
Well, forgive me, Your Honor. If I have misspoken, it is simply.
Or you have. So I'd like you to acknowledge that you've misspoken.
I have misspoken, and forgive me.
Good.
And it wouldn't be the first time where someone has accused me of having poor arithmetic skills, I assure you. Now,
So, and I'm looking at an affidavit from Capstone, which Capstone says that Capstone is the majority lender under the terms of the various agreements, having advanced 55% of the amount. That's that's what's in the record. So, all right. So let's assume you are the minority lender, right? And Capstone has made it clear it doesn't want to foreclose or doesn't want to go under the guarantees, correct?
that was its position at the time, absolutely.
Well,
Your
that's
Honor.
what we have in the record. It doesn't, the majority lender does not want to go after the guarantee, would rather do a workout. So, and the document doesn't say that the minority, as one might expect to see when there is when there is a group lending, that one or the minority lender can individually bring suit. It doesn't say that at all. It doesn't say anything about it either way, correct?
That's absolutely correct.
But what it does do is call both you and the other lender and Capstone one entity, purchaser, right? So
certainly.
there's nothing in the document either way that would let the court or anyone know whether it is. It's not. Let me say this: there's no specific language in the document one way or the other. Correct?
Correct.
Okay.
And if I may, Your Honor, a point you raised just now, the term purchaser certainly is defined. It is there in the record right in front of us, singular purchaser. Now, going beyond that preambular text, let's look at the agreement, four corners, as Mr. Richardson has encouraged us to do. There is no hallmarks of a collective action requirement. As Justice Schechter recognized, there isn't any sort of the traditional no action type clauses that would bar an individual lender from pursuing remedies, either here or when taken the set of loan documents as a whole, which she had done in rendering a decision, which is to look at the nature of the transaction, parties' expectations, what would be
So
commercial.
of course, in Beale, which is the leading court of appeals case of NCNH, which is also a case of my case, there was no language either way. Same thing as here. Beale says there was no language either way, and you can't tell from that document what the intent of the parties was, right? So that's exactly what we have here, correct? Except we do have some language that would seem to indicate one thing in the guarantees themselves, which is that both parties are together called the purchaser, and they're not called individual, and other documents which indicate jointly and severally and individually, which the bar is not a party to, which might indicate that the parties did intend. But there's no specific language either way, correct?
Absolutely correct. Now, if I may take up your first point, Your Honor, on Beale, you're absolutely right, that was at issue. There was no clear definitive language within the subject agreement. The Court of Appeals, of course, looked beyond that to the broader set of documents, as Justice Schechter did here as well, and said there's no unequivocal collective design. The same finding that Justice Schechter had here. And now, in terms of the security agreement with the joint and several language, again, you're right, that's the agreement that contains that classic language allowing it. However, there was nothing in the other agreements or the personal guarantees, for that matter, more importantly, that says individual rights or individual pursuit of your own debt is barred. Everyone has to operate through an agent or operate collectively with the lenders. And there's nothing in the agreement that says that that would be a requirement. Of course, that would make no commercial sense. And as a lender, one would expect, if there were a limitation on one's rights to collect the millions of dollars you have loaned to someone, it would be set forth in crystal clear terms.
And of course, but then on the other hand, of course, Capstone, who is the majority lender, would expect that its rights as a majority lender to try and work it out rather than take 6 cents on the dollar if the guarantee is enforced and the debtor individually doesn't have the money, would expect that its rights would be respected too, right? It's hard to, I think it's hard to tell from these documents what everyone expected this to do.
Absolutely. And with respect, Capstone intervened in opposing a receivership application, which was ultimately granted. Capstone never intervened to say, hold on a second, Arena doesn't have this right to pursue their own remedies. What they wanted to do with their portion of the loan, I will not speculate on. They didn't intervene to say that there was no right here that Arena had. And I see my time is up, so respectfully, thank you.
Thank you. You have time on rebuttal?
Your Honor, I would just like to point out one thing, if I may. Arena actually admitted that Capstone was its agent in the affidavit of Vincent DeGracia. That was before the court as well. So I just wanted to
That's what I thought.
Yeah.
That Capstone was the entity that was managing this, as it were.
Absolutely. Absolutely. They were the agent. Arena admits that in their papers.
And yet, for purposes of whether to pursue a legal course of action, you seem to have been summarily overridden.
With respect to the personal guarantee, absolutely. And with the primary borrowers as well, but they had different enforcement rights, different agreements.
Okay.
Correct.
Thank you. That's it. Thank you so much. Okay. Jeremias versus Lincoln Annuity. Lincoln Life and Annuity, forgive me. You may proceed.
Thank you, Your Honor. May it please the court, Greg Tuttle from Tuttle Yick on behalf of the petitioners Harry and Meyer Jeremias. The trial court made two major errors, one procedural and one substantive.
Let me get this straight, because I want to make sure I understand what's going on here. Harry and Mayor decide, we don't want to continue to fund this life insurance policy. It's expensive. We don't want to have to keep on having to contribute to that over the years. Am I right?
With respect to one of those two, correct.
Did either one of them contribute
Yes. So,
recently?
yes, well, Harry Jeremias had contributed from the date of the settlement agreement, which was January 2018, until November 2019, so for almost
So
2
for
years
1
after
year.
that settlement agreement.
Okay, and for the last 3 years, nothing?
That's correct, because of this they decided as trustees of the trust to enter into the life settlement.
That's nice. So the brother continues to pay for this insurance, and now the rest of them have decided, you know, I'm so glad he continued to pay for this insurance. We are now going to cash it out and take our unfair share of something that we relinquished the right to continue. What am I missing here?
Yeah, I don't think that's a fair characterization, Your
Really?
Honor. Well, first of all of even under the settlement agreement, all of the Jeremiah siblings are beneficiaries, and they continue to be beneficiaries under the
Even though they have decided not to, because you can't be a beneficiary to something that no longer exists. And the only way for this life insurance to continue to exist is that somebody has to pay the premiums. So these siblings should hop on the back of their brother who has paid the premiums and collect. Is that your argument?
That is not our argument. Again, Harry Jeremias continued to pay the premiums after the settlement agreement. The settlement agreement says that you can either opt in or opt out. It was a one-time option to opt in or opt out.
And so if you opt out, which I believe almost everybody, except for Harry for 1 year, opted out. Am I right?
It was 2 years, Your Honor. It was a January 2018 settlement agreement. It was November 2019 that he continued to pay the premiums to.
So 1 year and 19 months.
If the argument here on behalf of Abraham Jeremias is that Harry should continue to fund the life insurance policies, I think the claim there would be a breach of contract, and that he should make Abraham whole for the premiums that Abraham paid, but Harry has not since. I think that's what would make sense there. But Harry opted in. It was a one-time option to opt into the.
But in order to opt in, don't you have to maintain that obligation?
There's nothing.
You can just opt out again 15, 19 months later, and I can still cash in while you carry the freight?
There's nothing in the settlement agreement that says.
Answer my question. Is that what you're arguing? That Harry, who stopped paying, should benefit from the money paid by his brother to keep up this insurance policy?
I don't know, Your Honor. That's not what I'm arguing. Again, at the time the life insurance, the life settlement sale was entered into and executed by a majority of the trustees of the trust, Harry was an opted-in party. Even if you take their argument that Harry opted out in November 2019, and I would not concede that, I think that he opted.
But isn't the whole purpose of the opt-in that you pay? So if you don't pay, how can you be considered an official opt-in person?
Well, we know that it's not an ongoing. We know that
Really,
it's a
I can
one-time
pay
opt-in.
1 month. I can pay just, based on what you're arguing, if one of these siblings paid for 1 month and then stopped, Abraham, who foolishly continued to pay, all of his siblings are able to cash in on his back?
Well, again, Your Honor, that's not what happened here. Again, Harry Jeremias.
What happened?
Harry Jeremias opted in. He continued to pay the premiums up until the date of the life settlement sale. So the narrow question before this court isn't who opted in and who opted out when. It's whether the trustees still have authority over the trust. And their argument here is that, and Your Honor picked up on it, is that the trust had no purpose after the settlement agreement. That can't possibly be.
Those are your words, not mine. Continue.
Well, the trust exists to hold the insurance policies of Mariana Jeremias for its beneficiaries. Mariana Jeremias continues to live, and even if some, or let's take Abraham Jeremias' extreme position on appeal, and this wasn't even argued below, that all of the beneficiaries have now opted out under the settlement agreement, there's still a purpose to the trust, and that's because each opted out beneficiary under this settlement agreement is still entitled to a pro rata portion of the surrender value of each policy. So the trustee's decision about whether to hold on to the policies until a death event and ultimately death benefit, or to cash out on the policy now and enter into a life settlement is still relevant to those beneficiaries. It's the difference between getting paid a substantial sum now or getting paid much later. But it is a decision that Mariana Jeremias, in an irrevocable trust that has not been amended or revoked, conferred to the discretion of the trustees of her trust. And it's very important because to amend or revoke an irrevocable trust, you need the consent of you need a written, acknowledged form of the creator. There is no evidence of a signed consent of the creator to amend the trust and settlement agreement. She's not a party to the settlement agreement.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the Court. My name is Joseph Haspel. I represent Abraham Jeremias.
Have I completely missed this picture?
I think you hit it head on. And I also think that the proof is in the pudding. In the one deal that went through, that Harry was able to get the life settlement policy sold. He pocketed the money, didn't distribute to anybody, and it's gone in the wind. And that was $400,000 lost after Abraham has funded it.
Isn't part of the problem here what's in the pudding? Because there was a petition, and then a response to the petition, and then CPLR 404B contemplated that your friend would have an opportunity to respond to that, and yet for a variety of reasons, the COVID pandemic, the manner in which the courts were operating, et cetera, the judge decided the matter without the benefit of a response from your friend. So isn't part of the issue here we're dealing with what arguments were made, what arguments and evidence could have been put in but were not because the reply never came in?
You could look at the situation, and as a summary proceeding, and I went through this in the brief, it could be dealt with on the papers if there's no questions of fact, et cetera, and so on. In this particular situation, the real question is whether the settlement agreement superseded the trust. Whether there be a hearing, whether there be any additional briefing, and there was additional briefing in the motion to re-argue. But if there was, it wouldn't change the fact that the question is whether the settlement agreement supersedes the trust. This case presents a life insurance trust.
I just have a question, because I was under the impression that the trial court did not respond to the petitioner's request to schedule a hearing or even give the petitioners a chance to reply to the opposition, right? So there wasn't a full briefing here.
There was a full briefing. There was sufficient under the 404. Again,
Can you point me to the record where there was a full briefing? Because the way I read it, there was no opportunity for the petitions to be heard on the issues raised with respect to the intervention, including the settlement agreement. Maybe I missed it, so please point me to the record where those papers are.
Well, again, because of this procedural problem that was probably created by the COVID pandemic,
Right.
Counsel for the petitioners did make a motion to re-argue and did present all of their arguments. That motion to re-argue included everything, and it became the second appealed order that's before this court right now. So the question as to whether there was an opportunity, the answer is yes. The fact that the...
Can I just interrupt you for a second? Wasn't that a motion to renew?
It was a motion to renew and re-argue.
Was it re-argue and renew, or just renew?
I'm almost certain, without looking at it, it was a motion to re-argue.
And was there any discussion in the decision, or basically did it just say denied?
The decision of the court basically said we adhere to the prior decision.
But there was no discussion of all the stuff that didn't come in the first time?
Your Honor, unfortunately, some
just asking
judges
because-
don't send.
No,
don't
I
make
agree,
long
but
decisions.
it's hard to know whether the court really considered all the stuff that came in the second time, right? If all that the second decision says is I adhere to my previous order.
Your Honor is correct. I cannot tell you what was in the mind of the court, but I can tell the court that there was that everything that counsel says he was not able to present the first go-around was presented the second go-around, and there was a decision. That part is in the record. That part is clear. I can't tell.
So on the second one, was there any discussion about whether a settlement agreement could amend a trust?
The second,
Because that is a major issue, right? The parties are disagree about whether a trust can be amended by has to be amended by an amendment to the trust?
I don't necessarily see it that way, Your Honor.
Okay, but okay, let's assume I see it that way. Right? And if I see it that way, was there any discussion by the court below as to whether or not this one paragraph in this pretty brief settlement agreement could actually amend the terms of the trust, and in fact doesn't say anything about removing trustees or changing trustees, this paragraph 3, was there any discussion in either one of the decisions about that?
There was no discussion, but again.
And it wasn't brought up until the second one, right, all that stuff, when the party came to intervene, that's when all that issue was raised for the first time, and all we've got on that is, I adhere to my previous decision, correct?
I have to say, but there's a red herring here. Because there's no need, if you look at the trust document says that there's no requirement to fund the premiums, and at that point in time, the trustees can convey, and the settlement agreement was not an amendment of the trust.
I mean, we might agree on that. We might agree to that, but it's unclear to me that that was ever considered by the trial court is my issue. Because that issue didn't come up till the motion to, let's assume it's renew and re-argue, and there was no discussion of it. And it's not a throwaway. It is a substantial argument.
I'm going to let you answer that, and then we are done.
Your Honor, again, I cannot tell you what the motion court did. What I can tell you is that it had before it all these issues, and it rendered a decision, and unfortunately, I can't read minds.
Thank you. You have 2 minutes, counsel.
I believe we can tell what the trial court, whether the trial court considered our arguments and the papers in the motion to renew. And we know that it didn't, because if it had, it would have granted the motion to renew.
Let me ask you again, was it a motion to re-argue and renew, or just to renew?
It was styled as a motion to re-argue and to renew.
Well, it's either one or the other.
Right.
So renew requires something new that the court didn't have before it.
Yes.
First time, re-argue is, Judge, you missed something.
Correct, and it was
Those are two different things.
Correct, and it was really a renewal motion, and everything was guided towards that, because the judge didn't have any of our arguments on that. And the reason we know that it didn't consider it, it would have granted our motion to renew, and then adhered, upon consideration of our arguments and our evidence, adhered to its original decision. Courts do that all the time. Said, in a one-line order, denied our motion to renew, and cited 2 cases both standing for the very simple proposition that if you don't have a reasonable justification for introducing those arguments or evidence in your original motion, then your motion to renew is automatically denied. So we know that the court never considered any of our papers that actually supported the renewal motion. It just denied it on the reasonable justification prong. Just very briefly, I'd like to point to some of the new evidence that we did introduce in that renewal motion. And the reason we know that even Abraham took the opposite position that he's taking now, right before this litigation. In communications, letters, emails, signed certifications, all significantly post-dating this settlement agreement, Abraham says that there are 3 trustees, Harry, Meyer, and Abraham, that those trustees have, quote, the power to exercise all ownership rights, options, and benefits under the policy, that's page 872 of the record, that the trusts have not been revoked, modified, or amended. These are signed certifications to the insurers. In one email, I realize my time is over and I can stop there, Your Honors.
Don't worry, we have looked at your briefs and the record, okay?
Thank you very much.
Thank you so much. Robert Reynolds versus New York City Fire Pension Fund. You may proceed.
Good afternoon. If it pleases the court, my name is Philip Seelig of Seelig Law Offices. I'm representing petitioner appellant. This is a case of a firefighter who applied for accidental disability. And as you are acutely aware, most of these cases turn on whether it's an accident or an incident. But I believe that the court below erred when it made a determination that it wasn't an accident, when that determination in the administrative proceeding never occurred. What happened was there is a two-step process in the application. First, it goes to a medical board that has to determine whether a permanent disability occurred and a recommendation on that, and a second recommendation on whether there was an accident. What the medical board said in part in their medical board minutes on page 128 of the record, we note, and I'm quoting now, we note in his record and in the personal account that there are inconsistencies and a lack of witnessed accounts as seen in most CD-72s. Now, off the quote, CD-72 is the accident report that firefighters fill out. That would suggest a definition of an accident. Without this information at hand, the member failed to demonstrate that an accident occurred in the work setting. And so that is the only thing that his attorney, myself personally, went to the Board of Trustees to argue, saying what is meant by inconsistencies. It was not articulated in the medical board minutes itself. And so how do I, in a due process proceeding, argue that it's not inconsistent when they didn't point to what they meant by inconsistency? And the second was whether or not a witness statement was a requirement. The Board of Trustees, when they conferred after my comments, found that there's no such requirement for a witness statement for them to conclude that the member is entitled to the benefit, and that they wanted to consider the case, and then they laid it over till the next month. When the next month occurred, there was no discussion on the record, no issue, no opportunity for me to address as his attorney what inconsistencies they are referring to. It wasn't remanded back to the medical board, as they have the authority to do, to inquire from the medical board what was meant by the statement about inconsistencies.
So would you say that if we agree with you that the board failed to elucidate what those inconsistencies were, that at the very least this should be remanded for them to articulate that?
That's correct, Your Honor. But further, we think that it was premature for the lower court to rule that it was not an accident, and to even entertain that discussion since it was not brought up in the administrative process. And we didn't have an opportunity when presenting a petition on the Article 78 to address that issue because it wasn't at issue. So for the judge to do that, I think, was improper. At least I would contend that you consider that. But even if arguendo, you believe that the court was within his right to make such a determination, we believe that.
Well, really, counsel, isn't it that the court felt that that's what the board came up with? I mean, basically the court said, this is what the board said, that this wasn't, the petitioner didn't prove it an accident. So the question is really not so much that whether the lower court made a finding, it's really whether there's sufficient information in whatever the board said to actually sustain that fine.
Well, that's exactly what I was about to point out, that if arguendo, you believe that the court was empowered to make such a determination, that there was a determination it wasn't an accident, that it erred when it found that slipping on wet stairs inside a building when it was snowing outside is not an accident. It should be construed, and we have case law that we presented to you, that it is an accident. As far as inconsistencies, I don't think there is an inconsistency here. The statements, when made to a doctor or to a medical staff in an ER, they're not concerned whether it was slush or snow or water. They want to know what happened. Well, I fell at work. I slept down, I fell down the stairs. Of course, they're trying to determine whether it was syncope because he had some fainting, whether it was a seizure, whether he got hit by a car or something else, because medical treatment varies depending on how the person was injured. When a person says, I slipped on wet bricks and fell downstairs, he doesn't have to say, well, it was slush.
Right.
But in the CD-72, he clearly said that it was slush and wet stairs. It's consistent. He didn't say, I was playing softball with my kids on the weekend and I slid home and hurt my shoulder. It was clearly consistent, and I would argue that their assertion that it was inconsistent is not consistent with the record itself.
Thank you.
Thank you.
You may proceed.
Good afternoon. Kate Fletcher for the respondents. This court should affirm. In this case, the Board of Trustees denied accident disability benefits on a tie. In that situation—
That happens on every single case that gets appealed here. That's why we're here.
Yes,
So
Your Honor.
that is
But
meaningless.
under that fact, the burden of proof lies on the petitioner to show that there is only one possible conclusion that the record supports, and that is that his fall constituted an accident. The burden of proof before the Board of Trustees is also on the petitioner. In this case, the petitioner did not meet his burden of proof.
Here, the medical board did not identify what inconsistencies there were, and under our case law, they have to.
I would suggest that the Board of Trustees did. At page
Where?
681 of the record, they specifically asked petitioner's counsel whether or not the medical records were consistent with the CD-72.
So, okay, let's stop there. I don't know anybody who relays an event in exactly the same words every single time they talk about the event. And it seems to me that that is what your people are suggesting. That unless I'm still talking.
I apologize, Your Honor.
Unless the firefighter repeats every single time I fell on slush, that falling on a wet surface isn't the same thing. Slush is a wet surface. So if you say I slipped on a wet staircase in one place and you say more specifically I slipped on slush, those are the same thing.
I would like to point to two very specific—
Address what I just said.
Yes, Your Honor.
Because apparently the medical board thinks there's a difference between wet stairs and slushy wet stairs.
Well, there is—
I'd like you to explain to me what's the difference.
There is a difference between slippery under this court's case law and Morgan v. Carrick, where there were reports initially which did not mention liquid or wet, but mentioned slippery stairs, which is what he said at the hospital.
Here he said in his report at the accident, again, you know, it seems like the medical board, who should be more astute than I, seems to have completely negated the fact that this man lost consciousness as a result of this fall. So do I expect him to repeat exactly in the same words every single time some new face comes to him and asks him a question? No, I don't.
May I point to another significant difference, and then I'll make a substantially different point. The first is that in his first explanation to the hospital, he said, and I quote, that he felt when he was walking behind the department, and end of quote, on slippery bricks. Behind the department suggests an outdoor staircase.
And can you pause for a moment? In that notation, who made that notation?
The doctor did.
And
after
the
speaking.
notation says that the patient said?
Yes.
Okay, go ahead.
And so the patient said that he was walking behind the department and that he fell on some slippery bricks. I would also note that the CD72 is internally inconsistent. He says first that he slipped on slush that was on the first stair tread, and he also says that he slipped while entering the hallway to descend the stairs.
I'm sorry, counsel, you're making some very clear and cogent points here. But aren't we confined to review the reasons and rationale that were proffered by the administrative agency during the administrative proceedings?
At the administrative proceedings, they could not reach an agreement.
What about the medical board? They were 3-0 in their
And they
February 7th.
pointed to the inconsistencies, Your Honor.
But did they point to, did they specify these inconsistencies, or did they just say there were inconsistencies?
They said there were inconsistencies. But if you look at the fact that the Board of Trustees, when it had the medical board report before it and the record before it, asked petitioner's counsel, are the medical records consistent with the CD72? It's clear that there was an understanding of where the potential inconsistency lay. I would also say...
But so now we're left, ultimately our job here is what? The court below and our job on judicial review is to look for rationality. And so don't we now need to sort of hypothesize or speculate as to what the inconsistencies were to then take it that next step and determine whether those were rationally founded?
May I respond, Your Honor?
Yes.
Thank you. I would say that in a situation like this, the burden of proof is on the petitioner to show that there is only one possible reading of the record. That is his burden of proof. This is not a situation where the question is arbitrary and capricious. Was there some evidence here or some evidence there?
But wait, before it switches to them, right? Don't you have to establish that the medical board and the whole board together made a decision, one that this court has fully amplified, which it very clearly was not? The medical board's decision conclusory said there were inconsistencies but did not identify them. Did not.
It did not, Your Honor.
Okay. And so you are attempting to cure that deficiency with the finding of the full board, and I don't believe there's any case law that says that you can do that. Am I wrong?
I can't point to a specific case, Your Honor. I would say that in this case, the whole problem was that the Board of Trustees could not reach an agreement. So asking whether their lack of agreement had a rational basis is a challenging thing to do. And that is why the burden of proof must be on the petitioner to show that it had to have been irrational. There was no other way for the board to have behaved.
So if we look at all the documents, every single one which is consistent that said he slipped on something slippery and not, he was looking the other way, every single document, it may not have said slush, but every single document, including all the hearsay that really has no evidentiary value, but it all is consistent. So then we look at a document that says, no, it's inconsistent, but doesn't explain how. So if we look at the record and every single document said he fell on something slippery, which would be an accident, and the board says without elaboration that the documents are inconsistent, how can we find that the record only supports one conclusion? Because the board didn't give us enough information to figure out what the other conclusion was.
Well, in this case, I would just point, Your Honor, to Morgan v. Carrick. I think it is almost an identical case. I would also just respond to one other comment Your Honor made, which is that in this case, the petitioner fell while performing his duties. He has very specific duties, which are to let contractors in and out of the building. It is not a case where he was on his way to do his duty. He was in the middle of his duty. And it is inevitable that on a snowy day, slush will be tracked in and out. There's nothing unexpected about wetness, even if you accept that it was an indoor staircase, despite the fact that he had already described it on the day of his accident as an outdoor staircase.
Thank you.
Thank you, Your Honors.
You have 2 minutes.
Thank you. I just want to cover a couple of items here. One was the case cited by opposing counsel about Morgan. In that one, it was inconsistency because the original contemporaneous documentation was that there was no reference to any wetness on the stairs, and it was outdoor stairs in that case of the police officer. And then it was later changed by the witnesses that at first made no mention of wetness. So there's quite a big difference than what you've acknowledged already from the bench, that all of the documents talked about some wetness, although not always using the verbatim statement about slush. And you've also noted that that these statements...
What do you say about counsel's argument that this happened at work, but it's an incident, not an accident?
Well, every accident happens at work. If you're struck by a
Yes, but
car,
I mean,
it happens at work, but it's an
yes, but we're
accident.
talking this specific, in this specific
So
context.
his job was not to inspect the stairs for wetness. If a person is shoveling snow on stairways in a MTA and then slips on the snow, you'd say, well, that's part of your job. You're shoveling the snow. Here, his job was just escorting persons that came to do work around the building, out of the building, and that's not his job to
And there was
inspect.
nothing, the board didn't say anything about that, did it?
They did not address that at all,
Right.
but...
So,
but
I
the
mean, we
court
couldn't find
The
that.
court found that it was not an accident as a matter of law. So since it was raised by counsel, I at least want to give deference to that argument, and it suggests that that was not his responsibility. And that's... there are cases such as the Surveyor case, I think that's Sullivan, that we cited in our brief, and there are ample other cases, one recent in appellate court in the second department, Lonnie, where a sanitation supervisor fell on broken concrete while he was taking photos of a lot that had debris on it to give to the owner for summons. And they said, look, you're not responsible to inspect. It's not his job to inspect the sidewalk for defects.
Thank you.
I'll end with that. Thank you very much for your consideration, and I hope that you'll consider either remanding the matter back or awarding accident disability if you find that that's appropriate.
Thank you so much. And last but not least, Morrison versus NYCHA. You may proceed.
Thank you, Your Honor. And may it please the court, Cy Aidner for the appellant. The first issue on appeal is whether NYCHA met their burden as the movement, given that they submitted on their own accord building inspection reports documenting unsatisfactory treads, most recently 14 days before this accident, without addressing those documents in any way until reply, which we submit is in violation of two cases coming out of this department, Migdal versus the City of New York, and Henry versus Progrero, which stand for the basic principle, you can't wait until reply to meet your prima facie case. The second issue on appeal is whether Morrison, assuming that the burden has been met, has a valid prima facie case. The dispute below, which obviously takes center stage here in terms of the prima facie case, is whether the inadequate friction claim in the notice of claim, which was not carried over to the bill of particulars, is still valid for the purposes of creating an issue of fact under the circumstances. You know, the NYCHA cites...
Well, don't we have to deal with the constructive notice issue first?
You do, but notice...
Well, no, yeah, but...
No, yes, but...
If you can't get past the constructive notice issue, we don't even have to consider the other issues.
May I be heard on that, Your Honor?
Sure.
The testimony in this case is that NYCHA applied the paint, which reduced the friction below accepted standards.
Again,
That's cause and create.
we have to deal with the constructive notice issue because what made Gregory fall was wet substance on the stairs, no?
I would respectfully disagree. You can have, we walk on water all the time without slipping. The distinction in this case is that he slips on water. The water is on top of painted treads, and the coefficient of friction, as we find out through the engineer, violates 2 accepted safety standards, meaning it's too slippery when wet. There's a little bit of a distinction there, but there is a distinction I would ask this court to consider. It's not just the water, it's the fact that it's the water on a painted surface. You bring them together, the paint is there because NYCHA paints every 3 years or so. That's cause and create.
So again, do we not still have to establish that the property owner had sufficient notice or constructive notice of the wet condition before we can move forward?
No, Your Honor, because
No.
it is the paint that is the causative agent here.
But
No.
that's not even what your client said.
That's not what you're, exactly.
Your client said he slipped on the slippery substance. He didn't say anything about the paint. No one said anything about the paint until you put in an expert affidavit who wasn't there at the time. So, assuming that we believe your client that he slipped on the water, right? Doesn't there have to be some notice of that condition?
Respectfully, not under the circumstances of this case, because the case hangs on the existence of the paint on the treads, separate from the water. Thank you.
Okay. Counsel, you're up.
Good afternoon, Your Honors. May it please the court, my name is Diana Neyman of Cullen and Dyckman on behalf of the respondent, NYCHA. Your Honors, as you've pointed out, this case does turn on the issue of notice. My client has established its prima facie entitlement to summary judgment based on notice. It has submitted conclusive documents showing that it did have a janitorial schedule. It inspected the building on a regular basis. It inspected the building several times before, on the day off, before this accident happened. The accident did happen after hours, after NYCHA personnel left for the day. But before they left for the day, they did inspect the staircase. And there was no condition like that. And as you've pointed out from the appellant's testimony, he didn't see that condition himself when he entered the staircase. And he hasn't been in the staircase at least for a year before the accident happened. So NYCHA has submitted conclusive evidence that it didn't have notice, either actual or constructive. And the issue regarding paint, that claim was never asserted in the notice of claim, and that claim was never asserted in the bill of
No, it
particulars.
was asserted in the notice of
Well,
claim.
Your
but
Honor,
it wasn't put in a bill of particulars, correct?
what was in the
It
notice
wasn't
of
in the
claim
complaint,
is,
and it wasn't in the bill of particulars.
I'm sorry?
It wasn't in the complaint,
It wasn't in the complaint.
and it wasn't in the bill of particulars.
Correct, Your
But
Honor.
I did see it in the notice of claim.
Well, the notice of claim stated that the floor had an adequate coefficient of friction, but it did not claim that the paint on the steps created that alleged low coefficient of friction. And by the time the bill of particulars was served,
But you
that
were put on
language-
notice that that was an issue. So it certainly alerted the defendants that the coefficiency friction was an issue, sufficient to allow you to investigate. So I don't think that's your strongest argument, counsel.
Well, Your Honor, if I may respond, similarly as in the case of Mon Mysterio, that allegation in the notice of claim was related to the presence of the liquid or the slippery substance, not to alert the housing authority that the paint on the steps was an issue. If Your Honors don't have any further questions, I will rest on my papers.
Okay.
Thank you.
You may proceed.
Thank you, Your Honor. Very briefly, Monasterio was an assault case pled as a
Let me
premises
ask you this, counsel. When's the first time before the expert report that you served on the summary judgment motion, was there any indication in any of your documents or your pleadings or your deposition testimony that paint was an issue?
The first indication that paint was an issue, or potentially could be an issue, was in the building inspection reports, most recently 14 days before,
No, I'm
where it was
talking-
inadequate.
Right, but I'm talking about you, what you brought forth. Did you ask did you ask your client on deposition about paint?
We did not, Your Honor.
Did you ask the porter about paint?
Paint was not, yes, yes it was.
Oh, what did you ask?
The testimony from the porter, Mr. Santos, was that NYCHA would paint about every 3 years the treads Battleship Gray. He didn't know anything more than that. It was vended out to a third party. The sequence really was, once summary judgment was filed, then the photos were examined, then the inspection took place, and then came the test. Very briefly on Mastromanico, I mean, that was an assault case, pled as a premises case lighting, that then converted into a negligent security case. The key that I would ask this court to consider most respectfully is NYCHA submits building inspection reports where they find that it's inadequate. They stay silent on that like they don't
Counsel,
exist.
I'm glad you brought that up about the inspection reports because nowhere does it list a specific condition or the location. Am I correct about that?
I would respectfully disagree in this very limited regard.
Well, there were 2 years before, right? There was one in July of 16, December 16, May 2nd, 17, and May 18. Noted that the steps and treads were unsatisfactory, but did not mention the specific condition or the location, or even the stairwell.
Well, let me address that in 2 points. Number one, they produced those documents in specific requests to a DNI for that stairwell without any limiting factor.
No, but let's answer my question, because I just told you what I saw.
Yes.
So am I incorrect about this?
I think you're incorrect in terms of that stairwell because they...
Did it say stairwell A and B? Because there were two, A, B. Did it say which one it was?
Not on the document, but the demand requested just that stairwell. And why would NYCHA give stairwells other than which is responsive to this case?
Okay, thank you.
Thank you, Judge.
Oh, my goodness.